Welcome, everyone, to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. For our talk today, I will be holding questions until the end. For those of you that are pursuing education credits, if you are pursuing medical education credits, the sign-in sheet is in the chat box now. The APA continuing education link survey that you'll complete for your credits will also be in the chat box, but near the end of the presentation. Keep your eye on that near the top of the hour, around 50 minutes, 55 minutes to the hour, and make sure that you bookmark save that link so that you can complete it after the webinar closes. And make sure that once you complete that survey, you save your own version of the CEU certificates, a PDF of that for yourself and for your records. If you missed last week's talk in the series, Dr. Emily Haney-Caron and Lily Ramos's discussion of an eco-developmental framework for forensic mental health assessment with youth and probation is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube channel sometime later this week. And a version of these slides for those of you that have registered for the series will be available later this week as well. As a heads up, next week we'll wrap up Law and Mental Health for 2025. We have Dr. Douglas Lewis Jr. discussing clinical decision-making within distinct operational systems, a comparative workshop on military behavioral health and forensic psychology. After that, we will return on the first week of January in 2026 for another great year of Law and Mental Health. This week, you get a full dose of me. Today, I've decided to go ahead and go over a model of decision-making and bias that is used in forensic science and discussing its potential application in forensic mental health assessment. Now, of course, you see me on these pretty much every week if you come to these Law and Mental Health Series talks regularly. This bio has been in pretty much every ad that you've seen every week, so I won't bore you going through the details of the bio that I have basically forced upon you every week for the past couple of years. I will say it has been an absolute honor moderating this Law and Mental Health series. When I started at the University of New Mexico 3 years ago, I didn't even know that this was going to end up being a critical part of my job, and it is one of the most rewarding parts. I know some of you have come and expressed your support and thanks for it. It's greatly appreciated. If you do come up to me, if you ever see me and you say hi, I always do welcome that. The reasons I came to New Mexico 3 years ago, partly because of our forensic postdoctoral fellowship here, and ultimately, in my experience in forensic psychology, what I've been particularly passionate about is this broad goal of advancing the field both directly and indirectly. I want to leave the forensic psychology practice world better than I found it. And that's in both direct through my assessments, but also just as importantly, and sometimes I might argue for me personally, more importantly, supporting other people advancing the field as well. For those that want to enter it and do their own assessments, for those that are seeking information and disseminating this kind of information to other people, producing research that advances knowledge in the field. That's what all of this is about, to make this field as good as possible, as precise as possible, to answer those important questions that have legal, mental health implications and liberty implications for the people that we deal with. A couple of things before, of course, we get started here. These are the rules for CEUs that you get in every single slide. I have no financial relationships to the material that I'm going to present to you today, and these are my views and my views alone, and that I am presenting here. They don't necessarily reflect my division at large or the University of New Mexico. This is me coming to you from my experience and my personal perspectives in the forensic mental health field. As I discussed, what I'm hoping to discuss with you today is a broader strategy that has been used in forensic science to boost accuracy and how this might potentially be applied in forensic mental health examinations. I am not necessarily endorsing or condoning parts of this practice. Instead, what I would like you to do, I encourage you to consider what we can learn from what's being done in forensic science, including the pitfalls that have been found in forensic science examinations that we are vulnerable to as forensic mental health practitioners as well. I find it's always important to periodically zoom out and reflect on what we're doing and why we're doing it in our examinations. We can get into a little bit of an autopilot for the things that we have get into our own practices. And I think it's always critical to periodically zoom out and reflect. With that in mind, that is one of the goals here, is not necessarily to recommend a particular practice, but have you think about what you are doing and if there are other avenues that you could potentially integrate and how you might want to do that. So most of the work in linear sequential unmasking, this debiasing decision-making technique that I'm discussing, it originated in forensic science. I wanted to thank Dr. Jeff Kukuka at Towson University, who's also a longtime friend of mine, one for a lot of the slide content on the background of linear sequential unmasking in general, and for his consultation in me developing this talk so that I could understand and assure that I had an understanding of some of the more intricacies and the ins and outs of what has happened in forensic science that led to the development and the proliferation of this linear sequential unmasking technique in some of the forensic science examiners. When we do forensic psychological examinations, we of course want to do our best job. We want to answer a legal question as accurately, as fairly, as objectively as possible. But it is impossible to eliminate the potential for noise and bias in the examinations that we do. This image here is a tiered system of bias that you will see in many a forensic science article by E.T.L. Dror, who is a pioneer and influencer in linear sequential unmasking. And it talks about all the different ways that biases can affect our examinations. Everything from at its core, just human nature. All of us come in to any kind of task with our own biases. And these are universal in any kind of environment that we face. And the pyramid is designed to get into things that generalize to any kind of judgment that we make to very case-specific kind of things. At the very top being the specific data for your examination. Those tend to be highly influential. Now, what we're going over at the beginning of this talk is different types of materials that you would get early on in an examination. In forensic science and in human nature as well, one thing that we have seen as a trend is that even if you give people the same kind of data, the order that they receive that information or process it can influence their judgments. I don't think I'm alone in thinking about examples of even when I was a kid, perhaps in middle school. I can recall situations where I had friends that perhaps had a little bit of drama between them. And one friend said something had happened with the other friend. And without hearing that other friend's other side, I'm coming in a little upset, heated toward them. Why would you do this? And coming to the other friend. And then when I hear their version, all of a sudden a different picture is framed. And I felt admittedly a little sheepish coming in, assuming one thing had happened and then getting another story. In those early events, we can always wonder, like, what if I had heard this other person's side first? Or what if I had just waited to draw a conclusion until I actually got more information? This is human nature, that early information that we can get, we can overestimate its ground truth. And so it can shape not just our initial opinions, but how we perceive and see other information that we get as we're evaluating something. We see these kinds of principles in a number of different situations in general human nature and perceptions. Some of you might be familiar with this study where you present people and you prime them to expect a certain thing. So some people in a particular study, for example, were given a series of images that looked like a man. Some people instead would get a series of images that could look more like a rat. And then you give people a purposefully ambiguous rat man that could be seen as, for some of you, a person, and some of you could be seen as a rat. Now, if most of you probably are seeing more of a man, remember which one I showed you first here. But in general, what we find is if you are primed to look at photos of a man, people were more likely to see this ambiguous image as a man. And in contrast, those that were given continual images of a rat were most likely to see a rat. Now, how this might be relevant to more of our assessments is we also see that other kinds of information that we get that describe somebody or could describe people in general can shape how we interpret more ambiguous information. And these ambiguous circumstances, it is what's most critical for us in terms of minimizing its influence on our rather minimizing the noise of biasing information on our examinations for that ambiguous, really tough information to assess where we have to use particular expertise to come up with the best judgment possible. So if you read these words from top to bottom, I think many of us would agree that this goes from a more positive attribute to things that might be looked at as more negative. And we look at the same list, but we get it presented in reverse. And we get a more critical, we get a more ambiguous term there, critical. Now, is critical a good thing if you describe someone as critical? Is it a bad thing if you describe them as critical? Well, part of it might depend on the context and the early information you got about that person. If you are getting early information that primes you to see this person as more intelligent, you might interpret that critical descriptor as a more inquisitive kind of nature, a positive attribute. In contrast, if your early descriptions or early priming of a person are more negative, and you get that description of critical, you might interpret that description as more disparaging of the person. If we think about a forensic examination, if you've ever implemented a response style measure, and you got a score that was in one of those more ambiguous, indeterminate ranges, think about the information that you had earlier on about the person, and if you've ever interpreted the same score differently for two different people, and why that might be. If we have a lot of information about a person early on that might predispose us to assuming they are being genuine, we are at risk of having a bias of being more inclined to interpret that ambiguous information as beneficial and suggesting honesty, giving them the benefit of the doubt. Whereas if we were primed more negatively toward the person, that they were described to us by somebody else as a malingerer, or we knew they had a history of being determined to be feigning, we might be more inclined to interpret that exact same score as evidence of feigning. Now, if we zoom out, I'm not saying that you can't have different conclusions about different people. You're going to use all the information that you have. What we're saying here is that you interpreting that same score as evidence of being genuine or evidence of feigning can be shaped unduly by early contextual information that we were presented with first. Now, we have seen this in the forensic sciences, where presented with different information has affected different types of forensic examination practices. So when we look at thumbprint analysis or fingerprint analysis, forensic examiners are often tasked with identifying the little minutia in prints at a crime scene. And these mean like particularly unique aspects of the print that might be more discriminatory than others. And then oftentimes they're tasked with comparing that to, say, a suspect's print that is more ideal outside of the crime scene, of course, where they're just given, whether it's digital or put on a thumb pad, in more of these ideal circumstances. Now, if you actually present that ideal print at the same time while you're evaluating the crime scene print, this can affect forensic examiners' impressions of the quality of that initial print. What we have found in research in general is that if forensic examiners have been presented an ideal print at the same time, they are more inclined to assess the fit of that print differently than if they were just to evaluate it on its own merit. This not only affects identification of different kinds of unique aspects, but also forensic examiners' perceptions of whether the print is of high quality and even suitable for analysis or not. Similarly to these order effects, sometimes it's not as much the order, but the actual information that we get early, contextual information, as opposed to order effects that imply we're going to get the same information, but it's just when we get it. But sometimes we are given different contexts in a forensic examination, and we see that when people have the same information but are given different contexts as they look at that information, it can also influence judgment. We again see this in the general literature where you ask people how similar two people look, and you give them different contexts for the relationship between these two people. I think all of us have probably seen some sort of show or movie where there's that awkward moment where somebody said, "Oh, this is a photo of my parents," and they go, "Oh, you look so much like them," and they said, "Well, I was adopted." You're primed to see those similarities because you were given context that this is somebody that's related to me. You assumed that they were biologically related. Similarly, in a study here, if you prime people to saying that these similar faces have a familial connection versus a non-familial connection, that this is a teacher and student, you see different judgments in terms of how similar people actually look to each other. Now, where we have seen this in forensic sciences, where this can impact interpretations of evidence, is where you might expect to see a particular outcome. So again, when we look at thumbprint evidence or fingerprint evidence, we've seen studies here with forensic examiners and otherwise, where you present them with the crime scene print, and the print from the suspect. And you also provide them contextual information. Some people are informed that, well, we've got this suspect, they've confessed, we're looking for confirmation. Indeed, is this the fingerprint? Versus this person has claimed they've had an alibi, or in more explicit experimental conditions saying that this person was already in custody. Now, if you have these contexts, this pretty clearly should lean you one way or another. But in theory, in actual practice, it shouldn't affect your assessment of whether the print matches the other print. But in fact, we do see this in forensic examiners and in the direction that you would expect from the logic of the context, where when examiners are given information that would imply we believe the suspect is guilty, you are more likely to find similarities between the print and the sample print and the print from the crime scene. And the reverse is true, where if you are given contextual information that would suggest we wouldn't expect these prints to match, well, we see a higher rate of inconclusive or saying that these prints indeed have distinct differences that would not match each other. Similarly, we also see this in bullet analysis, where you have forensic examiners examine a bullet from the crime scene, examine a bullet from a suspect's gun. Is this the same? Does this bullet match? And presented with different case summaries. One summary being one that would clearly imply guilt, the other one having a lot more noise that doesn't necessarily imply that this suspect is guilty. And when we have these differences in context, we find that examiners, it can shape their opinions in terms of finding a match when we have context that would imply this bullet is supposed to match. When we have indeterminate case facts ago, we don't necessarily have evidence that would suggest this bullet's necessarily from the gun. Can you check and see, is this the same bullet? You are more likely to see exclusions or inconclusive evidence. Now, those two examples that I gave you were about if the person that we have in custody, or that the person that we suspect is indeed the perpetrator of the crime. But we see these biases affecting decisions of if there was even a crime at all. So in child abuse investigations, where there isn't necessarily a crime, where we're being tasked to examine, whether or not a crime has happened, if a child's injuries are from abuse or if they are from an accident or a medical incident. And in different scenarios, we've given data to forensic examiners to examine, in one particular study that I've cited here, a broken femur in a child. And forensic examiners were given different kinds of contexts about the family setting. And in one, there were implications in the context that the child came from that would suggest there might be high risk for an unstable or abusive household, where there was a history of violence in the home, that there was a number of different kinds of stressors going on. And other examiners were given a context that would suggest low risk, a high family stability, no identified implied history of violence. And we saw that that kind of context could affect examiners' determination of if the exact same injury on a child was the result of abuse or result of an accident. And in fact, in that last data point there on the table, we saw four examiners that were given the high risk context that would suggest that there was a history of intimate partner violence in the home, that there were a lot of familial instability issues, and they determined that or that the truth was it was an accident. That was only correctly identified by examiners 17% of the time. In other words, 83% of the time, the determination was wrong and incorrectly determined to be abuse. One of the most infamous examples of how this contextual noise can affect forensic examinations came in a study by E.T.L. Dror and colleagues in 2021 looking at cause of death decisions. This was a study used with actual medical examiners from the National Academy of Medical Examiners who were all looking at the same kinds of medical data for a child that had been determined to be found unresponsive with the same injuries. And everybody was provided context of why this child was brought to the hospital, but differing contexts. For some medical examiners, they were told that these injuries were for a white child who was brought in by their grandmother. And they were asked to examine this medical evidence and determine what is the cause of death of this child. Was it a homicide? Was it an accident? Or was it indeterminate? And other examiners were given the exact same medical information, but different contextual information. They were told that this was a black child who was brought in by the mom's boyfriend. Um, and you can see opposite patterns here in terms of determinations of whether or not the exact same medical data that were reviewed were determined to be caused by an accident versus homicide. So again, this gets at biases of contextual information that can impact if a crime has occurred in the first place, let alone if a specific suspect has engaged in that crime. There is a lot of articles, a lot of discussion about this particular article, a lot of controversy, a lot of heat from medical examiners who requested retraction of this article, accused of ethical violations. There you can see in the commentary a number of different articles and protests about this study. The goal of this study wasn't to say necessarily if race or relationships influence judgments. It was more to highlight the idea that contextual information that a medical examiner gets that should, in theory, not have an impact on looking at that medical evidence and saying if this was a homicide or an accident, nonetheless substantially influenced medical examiners' opinions on what a cause of death was. So we've seen this pattern in a lot of medical examinations and forensic examinations about how early information, contextual information we get can shape how we interpret other information that should be more critical to our examination. Now, in order to address this, E.T.L. Dror and his colleagues developed a process and proposed one specifically for crime scene investigations called linear sequential unmasking. So if we break this down, we're talking about in a sequence, in a specific linear fashion, revealing certain bits of evidence. Now, the goal of linear sequential unmasking originally was specifically for analysis of crime scene investigation. The notion was far more basic than, say, what we have in a forensic mental health examination, where the idea was if you have crime scene evidence, you should be examining the quality of that first and foremost before being exposed to any kind of suspect comparisons or target comparisons that could shape what you actually find and see in that crime scene evidence. Once you have examined that crime scene evidence and established your own baseline of what is the quality of this evidence, what do I see in this evidence, then you get the suspect data that you then can compare it to. And the idea here is that this would decrease our inclination to find matches where there might not be one. Or if we have other information that would lean us toward innocence that actually is not relevant to the match, that would unduly influence us to look for differences. You're examining the critical crime scene evidence for its worth in isolation before moving on to the other assessments that you're doing. Years later, Dror and colleagues developed a process, an updated version of this framework called Linear Sequential Unmasking-Expanded. That is greatly what we're talking about more when I talk about potential applications to mental health assessment. Part of the reason here is that this is a broader framework for many different kinds of decisions where we're not simply just looking at one bit of evidence and then comparing it to another. So one, this is designed as a framework for other kinds of decisions. Two, zooming out to talk about being more precise on your judgments, not just reducing bias. At its core, what ETL Dror and Jeff Kukuka have written about in linear sequential unmasking expanded is that instead of gathering all the data in your examination and reviewing it out of convenience or whatever order you happen to have it, being mindful about what you're going to look at and when you're going to look at it. So thinking about before you start your examination, what are the things that are most critical for me to look at, looking at that first, and as much as possible, eliminating your exposure or minimizing your exposure to irrelevant information. The added measure that is in this expanded model by Dror and Kukuka is also, from a practical perspective, documenting your process, including as you looked at the individual pieces of evidence, what you saw, what might be biasing about that evidence, and what you have done to minimize the potential impact of any kind of biases you acknowledge could happen from the evidence that you looked at. We have seen a number of different studies in the forensic sciences that have supported the use of this kind of sequential process of examining critical information first and reducing access to irrelevant information in improved decision-making and improved consensus in a number of different forensic sciences. This ranges from forensic anthropology and looking at skeletal remains to handwriting analysis comparisons to cause of death and cause of injury, like I referenced before. And also even in DNA, where we're analyzing whether there is a mixture of DNA. Is this a sample from one person, or are these multiple sources for the DNA, and how contaminated the mixtures are? Examiners, without the noise and other contexts of other crime scene evidence or other kinds of crime evidence, reached higher consensus on even things that outside of the forensic sciences we generally think of as more robust, say like DNA evidence. Because of this, a number of forensic sciences have praised and endorsed the use of linear sequential unmasking in forensic examination procedures, from pathological examinations, arson fire investigations, forensic entomology, teeth bite mark evidence. A number of different organizations have endorsed and increased the use of this process in their expert examinations. As forensic examiners in the behavioral health fields, we are all human that are tasked to do adjacent kind of examinations. And we know that similar kinds of biases apply to us as well. We are humans. We are also in similar kinds of contexts where different information could shape us. So one thing that I have been pondering for a while is how well the forensic science information on linear sequential unmasking expanded could potentially be applied to forensic mental health assessment. In order for us to assess that, again, at its core, I want to zoom out and let's look at what this model actually is telling us to consider when we do an examination. At its core, I would argue that what this model is telling us is that it is promoting the idea of reviewing your data points first and foremost in isolation, making sure you take a step back and judge this evidence in isolation before you judge it in the context of the grand scheme of things. When you're looking at a medical record, looking at and evaluating that record before you look at it in the context of all the information so that other information isn't shaping what you're reading, recalling, and judging about that medical record. Another piece here is that the most critical information to your forensic question that you are tasked with assessing is the information you should ideally be reviewing first. The things that are most critical to both giving information, but also fairly and objectively giving information to the legal question. That's the stuff we should be looking at first and foremost. We should also be assessing that information individually and then incrementally. As an example here, if you are doing a competency examination and you are reviewing psychological records and they document a history of psychosis, well, in isolation, we know that a history of psychosis increases odds for compromised competency relative to someone who has no history of psychosis in a vacuum. So in theory, individually, those records would increase the odds that the person that we're examining has compromised competency abilities. But if we're reviewing this information after we have interviewed the person and our concerns were more about retention of information, they seem psychiatrically stable. We know they're on psychiatric medications. We saw no evidence of delusions, hallucinations, disorganization. Well, this history of psychosis might not actually incrementally increase the odds of not competency here because we didn't see clinically that information. We came in to reviewing the records looking at concerns about retention of information. So that psychosis might not actually increase the odds of competency of a compromised competency in this particular person if they're currently psychiatrically stable. And then we want to minimize our exposure to irrelevant information. Now, as I'll get into later on, sometimes this is not practical, but these are some of the challenges in a forensic mental health assessment. Now, one question here in terms of an organization of looking at the most critical information first is what is most critical? That's going to differ in different kinds of legal questions. Different forensic evaluations that we do require us to look at different things. And we don't have a consensus on this right now. But according to the principles of linear sequential unmasking, there are 3 general guidelines of data that you would look at to determine what kind of information you want first and foremost. So ideally, the information that would unduly influence our judgments should be looked at later relative to information that we would say is less biasing toward an examiner. Data that is more objective, information that we would say lends itself to far fewer interpretations, more basic ground truth kind of information should be reviewed early on. And ideally, more subjective information that has more error rates, a number of different interpretations, would be looked at later. And of course, relevance. The most relevant information to inform your examination, in theory, would be the stuff that we would look at first. And the things that are less relevant to the legal question we're tasked to answer should be some of the last things that we look at. Of course, there can be natural tensions here. I think many of us can think that there are things that might be super relevant or even essential to answering a particular forensic question, but that nonetheless is also very subjective and also biasing. There are some things that might be purely objective that are less relevant to the question. So, one of the challenges that we have in any field, forensic mental health including, is how we balance this to determine what information we're actually going to review first. That is something at an individual level that we would be assessing at this point, and something that we are continually exploring of general consensus, which, spoiler alert, we don't really have for the few forensic questions that we've looked at. In terms of practical ways you could potentially use this mindset in a forensic examination, we can again look at the forensic sciences and an example worksheet that Adele Quigley-McBride and colleagues developed to implement linear sequential unmasking in forensic science work, where examiners are tasked with documenting the information that they reviewed, where they got that from, and then rating that information on these guiding principles. How biasing is this information? How subjective is it? How relevant is it? And then also documenting why this information might be biasing and what the person did, if anything, to reduce that kind of bias. Now, one thing I want to emphasize here as we get to this worksheet is that the types of information you look at aren't necessarily going to be universally rated even within one of us. So in other words, as we get to a psychological testing might be more relevant to certain legal questions than other legal questions. And even within the same legal question, if testing's already been done, if the testing has been normed on a population that does not apply to the person in front of us, that testing might be less relevant for certain people that we examine relative to others. So you're doing these worksheets according to rating the specific task that you're doing at the moment. So we wouldn't expect every time you reviewed a certain kind of record, you would rate its biasing powers, subjectivity, and relevance exactly the same. Adele Quigley-McBride and colleagues have an example of how this might be completed for the forensic sciences, and Mina Ratkalkar and Adele Quigley-McBride have developed an adaptation of this for forensic mental health assessment. Dr. Ratkalkar added this perceived credibility element to forensic mental health examinations if you were going to implement this into psychological practice, which is what the credibility of the actual source that you're getting the information from. And so here's an example. And again, we can disagree in general and even by case of where we might rate biasing power, subjectivity, and relevance and credibility. What I'm challenging you to do is to consider this or look at how considering these things as you get information might affect your examination or your approach down the road. So as one example here, you do a competency examination and you first get a referral form before you've even interviewed the person. And you look at how biasing, how subjective, how relevant that information is. And again, this can differ across different examinations. Sometimes I know I get referral information from the attorneys that's fairly minimal. That doesn't give me a lot of info. That might not actually be biasing because I just don't have a lot of contextual information they've provided. Other forms that I've been given have had very, very colorful, very strongly anchoring kind of language that would give me reason to believe this is calibrating my expectations for what to see in this person. So I would want to identify if I'm getting a lot of information that is presenting this competency examination as it is painfully obvious this person can't even do basic things, that could anchor me to examine or to see deficits that might not be as strong as I would see if I didn't have that information at the beginning. So identify, what do? Well, I take this information for what it is, and I identify other kinds of reasons that this attorney might see or might interpret this kind of information in a way that wouldn't necessarily suggest that they are not competent. I can do this for a number of different other pieces of information. Something I've discussed in other law and mental health talks here is that when we review records of past examinations, sometimes there is information in there that could be quite relevant to our examination, say other background information or if recent testing has been done. But do I really need the other examiner's opinion on their interpretation of that in terms of competency prior to my examination? If I don't, one thing we have done in some practices here, if I want to shield myself from some information in a record while looking at other ones, is having a colleague, sometimes postdoctoral fellow, being able to review the records for me and telling them specifically, I want information from these records, anything that's related to this. What testing has been done? When was it done? Was it valid? And then they can give that to me without me looking at the other records ahead of time. And then only after I've done my evaluation, looking at what did this person think? What did this other examiner think of all this information they had? And why might we be differing, or why might we have arrived at the same opinion? So you can do this kind of consideration for any kind of data source that you have here. You want to think about why the information I'm reviewing might shape my opinions or skew me, nudge me toward a particular side, and things that I could consider or do to make sure to increase the odds that I'm reducing that undue influence. One example for cognitive testing here is also that kind of a priori thinking. A lot of the cognitive tests that we do are going to give us a lot more data, a lot more results than we were actually considering at the moment. So thinking about specifically when I do testing ahead of time, what am I expecting to see, or what deficits specifically did I observe that, if we see impairment here, would increase the odds of a finding of not competency? And if there are impairments on this cognitive testing, but I hadn't observed it during the examination, and I wasn't expecting to see it here, then perhaps I should keep that in mind so it doesn't unduly influence me to see the idea that somebody has a deficit and then use that to fit a story that I had that this person might have cognitive deficits. Well, they might have them, but if they're not actually relevant to the competency related deficits that I saw, they might not actually inform us on this person's current competency related abilities. So again, this is prompting us to just think about ahead of time, what do I want from the data I'm about to look at? How could this data shape my opinions in ways I don't want it to? And what could I do to decrease the odds of that? Another way we can implement these principles in report writing is we can compare how we would typically present collateral records that we looked at before. So this is all the data I looked at in an examination. This is de-identified. Certainly, all these records show the court what I have looked at and considered in this examination. It doesn't really tell us when I had that information. In contrast, if I add a little bit of data that clarifies this is what I reviewed initially prior to meeting the defendant, and then these are the things that I reviewed after I had already assessed competency related abilities. This prepares me for potential cross-examination of different kinds of factors that could have swayed my decision or coming in with certain biases in the examination. It helps me be transparent with others about what I did, why I did it, and perhaps why you might better trust my impressions than if I didn't share this information with other people. Now, one big issue we have here is what is the critical juncture in an exam? So my relative point here is relative to when I examined or interviewed the defendant for a competency exam. Well, there's differences in different types of examinations. What I'd prompt you to do, say, for multiple clinical interviews for the same kind of forensic exam, is it helpful to tell the court or to know what information I had at interview 1 versus interview 2 versus interview 3? If I'm doing a parental fitness or a custody evaluation that involves me looking at multiple parents and caretakers, what information did I have when I talked to parent one? What information did I have when I observed parent-child interaction? What information did I have when I talked to the other parent? And this can help provide context for the judgments that I have later on. So in zooming out here and thinking about how this might help with forensic mental health assessment, again, the idea here is we're centering the most critical data first and foremost. We're reducing our exposure to irrelevant information, or at least reducing its influence. It encourages us to think about how we might be swayed and how we might be able to reduce that undue influence of information, and limits that range of confirmation bias of coming to a predetermined conclusion and seeing what we already think we're going to see. Other benefits, well, transparency. We, both in general research and in practices, oftentimes we are advocating for showing our work. It helps us be as clear as possible with the people that are tasked with assessing our work of why they should trust us. It can increase trustworthiness, provided that trustworthiness is merited. And what I mean by that is if we've done an examination that has a particular shortcoming to it, well, we should be transparent about that as well. And it increases our effectiveness of being able to communicate not just if you should trust my work, but whether you should give this certain piece of evidence more pause, because I was presented with this ahead of time, and it might have shaped my impressions. Now, this is what I did to decrease the odds of that, versus somebody that says, "Yeah, that could have shaped my opinion," and I can't tell you what I did to reduce the odds that impacted. I can only tell you that it could have shaped my opinion. Different implications there for how much we should trust impression evaluations and interpretations of that data. It encourages us again to reflect and be mindful about when we review evidence and how we review pieces of information. Now, the early results on looking at lay people's interpretations of forensic mental health data would suggest that perhaps this sequence isn't effective. To briefly summarize here, there was a study with lay people looking at an abbreviated risk assessment scale. They were then told that the risk score, if you applied the risk scale correctly, would say a 12% risk of recidivism for sexual offenses, and then asking the person, what do you think their risk is? And they had people look at this in three conditions. One, they were only given the data to score those risk items, only the information that was relevant. Other people were given additional information that could skew our perceptions of sexual violence. And then other people were given this in a sequential manner, where they were first just given the essential information for those risk items. Then they were given the irrelevant information. And then they were asked their impressions. And what this study found was that if you got that irrelevant information, regardless if it was sequential or at the same time, you were more likely to deviate your score, and consistently in a way that boosted risk, as opposed to those that weren't given that information at all. Now, one thing I want to emphasize about the consideration of this is that in this particular study, the participants were not tasked with evaluating the evidence individually in the sequential information. In other words, they weren't asked to first estimate their risk after getting the only relevant information, and then asked after the irrelevant information, is your opinion different, and if so, how? That is, if we fully adhere to the sequential model, we would be saying, first, once you look at that information, start to articulate and consider your impressions. And then only after you have done that for the relevant information, do you then look at the other information and think, do we reconsider? And the reason that might be important is a study that I could talk about for an hour, which of course for time I'm not going to be, that the other Dr. Perillo here at UNM, the superior research mind here, has led a study that I, Dan Murray, and our former grad students, Sarah Kaiser-Itri and Masha Berman, did, where we were not intending to look at linear sequential unmasking. We were looking broadly at expert opinions, and we had them do a simulated criminal responsibility examination and rate things like evidence strength, search strategies for a different study for a different purpose. Now, what our examiners did, they had access to a number of different simulated case materials, and they could look at whatever they wanted in whatever order they wanted. And we asked them to do that. Look at what you think you need to determine insanity. And then once you're done, tell us your opinions. And we wanted to look at different search strategies and different variables that I'm not going to get into now. But we saw a couple of things. One, there was significant variability in what people thought was what they wanted to look at first. Even the things that were the earliest looked at were still a wide range, and nothing that we saw universally were things that people looked at first and foremost. What I really want to get at here is the one big surprise that we saw is in this study, in phase one of it, we explicitly asked our participants to be biased. We told them you are supposed to find for the prosecution, or you are supposed to find for the defendant. And this is the one time we didn't see adversarial allegiance. And we were really puzzled, where we were saying, wait, we've seen adversarial allegiance in other studies where we've done just like this. We pilot tested these materials. Dan Murray consulted on this. The NSF panel that funded this study reviewed all these materials. We've been doing this study for 6 years. How did we not find adversarial allegiance? And we had a number of different ideas. One thing that jumped out years later after we finished the study that Jen processed is one aspect of our study was we wanted to look at how different influential factors impacted people's interpretation of the evidence, which would lead to interpretations of insanity. So what did we have people do? Well, after they reviewed a case file, we asked them to evaluate its quality. We asked them to evaluate how relevant they thought it was to their examination and how well it shaped a finding of criminal responsibility. And then when they reviewed the next file that they looked at, they did the same thing. They rated its quality, they rated its relevance, they rated how strong it was to suggest responsibility or not, and so on and so forth. We were not intending to test this linear sequential evaluation, but in the process, we believe it seems that one reason we might not have seen adversarial allegiance effects when we asked people to be biased is that there was this driving mechanism of actually sitting down mindfully with each piece of evidence and giving it its proper worth, and then moving on to the next piece of evidence. So it could be that this sequential aspect is a particular driving force in what could potentially minimize the impact of other biasing factors on our examinations. Now, practically, there are a number of things that could or could not work for doing this kind of process in a forensic mental health examination. Of course, we have a lot of degrees of freedom in different types of examinations that we do. There are not as clean of steps as, say, fingerprint analysis has an explicit, you are analyzing that print, you are comparing it to other things, and then you are saying how similar or different they are. The language across different states can change, and oftentimes some jurisdictions might give a specific guidance down to the instrument. Some jurisdictions might tell you broadly what constructs or what questions you're answering, and you have a lot of clinical judgment in order to how to assess that. This complicates establishing what kind of data is relevant to the examination or how you might look at it. Our data sources don't necessarily inherently tell us what we're going to find. If you have ever looked at a behavioral health record, think about what you might learn from a person about looking at it. There are a number of different types of data that have nothing to do with psychiatric history or the specific question you're looking at that could be in those records. Things that are irrelevant, things that are biasing, things that are very subjective. So we might not know what we're going to find out until we actually look at it. Human factors. I want you to think about how you start a forensic interview with an examinee, and then think about what is actually most relevant to your interview. Well, what if you eliminated all the irrelevant questions? Well, are you actually going to get as rich a data if you haven't established a comfort level or potential rapport building with some defendants or some examinees versus if you sat with some of that irrelevant but easier data for somebody to respond to and ease them into the examination? We have a lot of variability in our practices and our perceptions of what is relevant or not. One of the few examinations of actually what is relevant or not in linear sequential unmasking for forensic examinations, a study led by Christian Stevens, who is now in his first year as a PhD student at Iowa State with Tess Neal. Him and his undergrad advisor, Jenny Cox, they surveyed psychologists and mental health practitioners in a number of ways for different data points and competency of looking at how relevant, subjective, and biasing did people think certain data points were. And we didn't see consensus there. We see a lot of variability and really no source is being perceived as definitively more or less biasing, objective, or relevant. And then from a practical perspective here, um, anybody that is thinking about ahead of time what I might want to review, how often does your examination actually go the way that you anticipate or want it to? Anybody that's ever tried to get medical records or tried to contact a collateral contact knows that sometimes you are purely dependent on timing, on luck, on other people's willfulness. So in a vacuum, even if we want to review things in a certain order, maybe it's not feasible to actually do that. But to get back to the core points here, because of the practical challenges here related to all the noise and practical issues in forensic examinations and all the degrees of freedom we have in doing mental health assessments, it seems highly unlikely to me that we would be able to adapt linear sequential unmasking in as faithful, precise a way as some of the forensic sciences. But I don't know if we have to do that. The question from some of our preliminary work is perhaps it's less about establishing an order and more about a question of is a driving force in arriving at more precise findings in our forensic examinations, more about being mindful ahead of time of what we want to look at and recentering our evaluation of individual pieces of information and evaluating that information for its worth before we look at it in the broad context of things. So again, I'm not advocating a yay or nay, should we implement linear sequential unmasking in forensic practice, or should you be doing it or not? Instead, I encourage you to just reflect on what you consider you can learn from what's being done in forensic science, including your current practices in your examinations, when you most typically look at certain things, and if that's the way you want to continue to do that, how you attempt to use information as precisely as possible, and to continue to explore how you might improve your judgments as accurately, as objectively, as precisely as possible. So with that in mind, here is your QR code for the CEUs. We are at the top of the hour, but I know we do have a couple of questions here so far. I will try to scan through a couple of these the best that I can. The link to the CEU survey is in the chat box too, but you can also scan that all that. So somebody asked if you recommend testing before reviewing records in detail. Some of that really might depend. I do think that if you have records prior to your opportunity to do psychological testing, there is some practical information that would be critical to me to deciding whether or not testing is appropriate or not. And so one question I would have is what has been done before? Depending on what you are examining, would we expect practice effects where I would say that doing testing would actually be inappropriate for me because this person has already done this test before? Or do I have sufficient information based on the background information I have and other tests for, say, more stable constructs that might give us enough essential information that would decrease the odds that this testing is going to be helpful? So there's not necessarily a yes or no. I would think if you have records, you want to know, methodologically speaking, if certain tests have been done before. The question is, are you looking at those results ahead of time and what information that might want to provide? And that's going to depend on the legal question that you have and saying how much those prior results could sway you. Let's see. Somebody asked Joel, saying, going back to the white black study, when medical examiners demanded a retraction, what was their argument? Uh, well, there wasn't one. There were several arguments here. Some of them were very personal about the researchers, everything from specifically accusing them of actual data fabrication, which resulted in an external audit that had to be demanded of looking at the data and the records. Some actually accused some of the medical examiners that participated in it of having an agenda and being biased. Some others made more of a conceptual argument of looking at base rates and saying that this is illogical because we have base rates that would say people of a certain race or relationship are more likely to have engaged in abuse or violence than others. And so that does increase the odds that this cause of death was a homicide rather than an accident. Of course, the argument from outside of medical examinations would be that if you continue to use those base rates as a justification, of course they're gonna continue in perpetuity, and also that shouldn't actually affect the examination of the evidence in isolation about whether this particular bit of evidence tells us that this was an accident or if it was a homicide. Um, let's see. What info to look at for suggested tautology? How can one answer that question without first looking at all the info to see what's there? Therein lies a critical issue in forensic mental health assessment here, is that we do not have a universal answer to what a type of data is going to give us. So we can do a clinical interview with the examinee themselves. Well, if you do a structured interview, then we know what information we're going to get, what we're going to ask for ahead of time. But we don't actually sometimes have control about how our examiners respond to questions. They might give us a number of different other types of information that is less relevant. When we review records, we don't know really what we're going to be able to look at, and we can't really unring that bell. This is all the more to me why it's less critical for us in forensic mental health to be thinking about what order should we be looking at things, and more thinking about what kinds of information could be unduly influencing us and what we can do to minimize that once we see that kind of information. Right? Oh, I have a number. Let's see. I'll try to read through this last question here. Is there any off-ramp from this bias toward more treatment? I'm going to have to sit with this question just a little bit longer here. Bear with me. Um, just had a conversation with a deputy who advised me mental health diversion becoming problematic because it's attractive to offenders. It applies to everyone who admits poor judgment in the controlling offense, as possibly due to mental illness impairing his judgment. Not sure I agree with that fully, but it applies to everyone who justifies bad behavior as related to poor insight about obvious cognitive or behavioral dysfunction. Behavioral dysfunction, I'm not so sure there. Felons tell me that I'm lucky they offended because it means I have a job. Is there any off-ramp from this bias toward more and more money and more treatment when people hurt people? All right, I'm not sure I'm quite following the end track of this question, but in terms of mental health diversion, it is possible that when you get initial framing information about why this evaluation was asked for in the first place, that can shape us toward looking for and finding that particular information. You would apply the same biasing techniques here that you would in any kind of examination. And I think just taking a step back here in terms of what Jeff Kukuka, ETL Drawer, and others have told us through these exams is it's less important to be looking at this is my way of eliminating bias is following these procedures. Instead, it's promoting us of doing all the other things that can minimize that bias by being mindful of what we're looking at, mindful what we're considering, and doing that piecemeal kind of examination as safely and effectively as possible. So we are past the hour, of course. I want to thank all of you for joining us. I know I'm usually the one just thinking presenters here, and I appreciate you sitting with me for this hour. I hope you got something out of considering what we do and why in our forensic examinations here. Next week will be our final Law and Mental Health series of 2025 when we have Dr. Douglas Lewis Jr. We'll be discussing clinical decision-making in distinct operational systems, comparing military behavioral health and forensic psychology. And then we will take 2 weeks off for the holidays before we return in January. So we hope to see you next week for one last 2025 Law and Mental Health series. Until next time, take care.